Strata Adviser, Hynes Legal, former Commissioner for Body Corporate and Community Management. And this is usually the moment where I would hand over to Frank Higginson, partner, Hynes Legal, for Frank to introduce himself and to say hi. But Frank's not here. Frank is off on some very, very well-earned R&R, I should say. And you've just got the pleasure of my company for the next half hour. But I can tell you that Frank cannot wait to get back next week and get back into the webinar series. He'll be refreshed, reinvigorated, and ready to roll. And we'll talk about next week at the end of today. But just a quick reminder that if you are watching these, please be sure to register. That way you can get some content from us after the webinar as well. It also sets up a good reminder for you to tune in. Not that you need one, of course. What else would you be doing on a Thursday afternoon? Today, we're going to talk about strata regulation, new strata regulation, but we're not talking about the strata regulation that started, 11 days ago. No, we're actually going to look ahead into the future. So we are now in the second week of brand new regulation modules, and I'm already hearing a few bits of feedback out there in the sector about how they're going or how they're not going, as the case may be. And so that will be interesting to see how that all pans out in the not too distant future. But what I'm going to talk about is about where we go from here, what happens next. For anybody who's been keeping abreast of changes in Queensland, indeed changes around the world, you'd know that there are a whole lot of issues that are yet to really be covered and yet to really be tapped in Queensland. So where's that at? What do we think might happen? I'd like to encourage everybody who's watching today and anybody who watches this afterwards in the recording to get a bit interactive and to throw a few ideas at me and throw a few ideas out there for discussion. I don't think there's anything like a stupid idea or a wrong idea in this particular situation. I think this is very much an open forum to sort of see where we get to next. So, okay. What do we know and what do we think might happen in the future? So just to clarify, we've had a very, very long review and we've now got new regulation modules which are part of that. But that's only one very small piece of the strata puzzle. There are these big, big issues such as pets, parking, smoking, scheme termination, insurance that haven't been tackled. And they're the leftover bits. So the new Attorney General has announced that those things will be looked at and in the context of what is called a Community Titles Working Party. I've actually been involved in some of the briefing about that party. I was fortunate enough to attend a briefing held by the department who sort of gave an indication of how they think things might pan out. I'm not going to sort of talk about any of that in detail because it's not been publicly announced. I can talk about the general process though, because that has been publicly announced. The Attorney General spoke last week at the Strata Community Association conference on the Gold Coast and talked about the formation of this group. My understanding is that it will work in a series of phases or tranches, if you want to call it that. So given the scope of things left over, and when you think about it, you could probably spend months and months and months talking about reforms to keeping pets by themselves or even smoking. So I think it's fair to say that the government has decided to split these things up. And so the role of the working party will be experts in the sector, looking at issues, looking at pros and cons and options, and then giving recommendations and advice to government. So it's not going to be a decision-making body, we don't think. What we do understand is that the first stage of that is going to be looking at the most pressing issues. And these are the things which have got a bit of time sensitivity about them, or in which has already been some public announcements. And by public announcements, we mean election commitments. And those are out there in the public domain. One of the election commitments which has been around for a little while is the termination of schemes, and that's the situation where you have your entire scheme and then the entire scheme decides or is thinking about deciding to sell to a developer to have the whole block redeveloped. That has been an election commitment for a while. We can expect that to be looked at as a priority. The other big priority is going to be the insurance issue that has emerged over the last, well, gosh, couple of years, and in North Queensland in particular. And then I think we can expect all of those bylaw issues to get a Guernsey probably after that. And I'm going to talk about those in a bit more detail in a minute. What we don't have is any timing on milestones. There haven't been any firm commitments made at this stage, but what I do think is that we can expect to see some movement, some development in this term of government. Remember, the term of government in Queensland is 4 years. I mentioned just before that the Attorney General spoke last week at the SCA conference on the Gold Coast, and I was actually on the panel with her when she spoke. What emerged for me was that the Attorney General very much keeping an open mind about things. Did reinforce her thoughts that the keys were education, information, and disclosure. I think that's a bit of a double-edged sword in some respects, because while it's great that the attorney's got an open mind, what that might mean is that we find ourselves revisiting or going back to things that we might have thought were already settled. And that's possibly not going to be a good thing. What it also does is it throws the spotlight really strongly on the idea of information and education to get people making better decisions for themselves. So, what might happen? Let's pick out a couple of issues and let's sort of explore those in a bit more detail. And as I say, chuck through to me your ideas and your thoughts as we go along. So the first one on the insurance issue, we've had the Australian Competition and Consumer Commission do a review and issue a report, and a response is due to that from government. At the same time, the state government made a commitment to do some work around alternative insurance. So at the moment, the Commissioner, my successor, can approve alternative insurance. So if you are a scheme and you can't get the legislated insurance, you can apply for an alternative to that. Usually that means the alternative is that you get insurance for less than the value of your building. Not always, but that's one aspect of it. The government has committed to changing that to make that an adjudicator's order. And the advantage of that is that when an adjudicator considers it, those decisions will get published. And so for any building who is needing guidance on what is and isn't alternative insurance, that's actually really useful. The other aspect of it is that an adjudicator kind of has the same function, the same kind of role as a magistrate. Taking submissions, considering natural justice. So there's a bit of a difference between the Commissioner exercising her discretion and an adjudicator going through a natural justice process. Does that necessarily mean a better outcome? Not necessarily. It'll just mean an outcome that I think will be much more thorough and much more transparent. That's the change that's coming. And also the other change that's coming there is the commitment to give the adjudicators much more guidance about what is alternative insurance. At the moment, it's just a bit nebulous. On the ACCC side of things, the big focus there was on the issue, was on the commission issue. And I think that's definitely where the ACCC sees themselves going on this one. Does that mean that's where Queensland will be going as well? Remains to be seen. Does that mean that the Queensland government will decide that it will no longer be possible for a body corporate manager to take commissions? That could very well be an outcome. What does that mean for bodies corporate? What does that mean for unit owners? That's a fantastic question. That needs to be teased out a little bit, that one. And then we got on to the topic of scheme termination. Now I'm going to do something a bit different here. I am going to attempt to share my screen. Now, given that we don't have Frank here this week, this might actually be a bit easier, but please bear with me, everyone. You probably can't see that very well, unfortunately, so that's not actually the best visual. But what I am looking at here is the governance report or the recommendations made by the Queensland University of Technology about the issue of termination. And so the QUT report looked at the current situation and decided that it might be appropriate to allow termination to occur in some circumstances with a 75% threshold. I've got to say, having reread this document today in preparation for this webinar, the QUT recommendations went into an awful lot of detail about what would and would not be appropriate for the purposes of scheme termination. That one promises to be a difficult issue, and I think the threshold issue that the government's going to have to look at is just how significant termination is at the moment. And so, for example, are there a lot of buildings in Queensland which have reached the end of their natural life, would actually be in the benefit of all owners if they could terminate and redevelop, but they're being prevented from doing so because of the current situation, which is basically 100% agreement. Is there a lot of that happening in Queensland? That remains to be seen, and that's going to be one of the issues that has to be covered. Let's talk about the thorny issue of pets then. This has been in the news, not so much in Queensland, but in New South Wales. And again, we'll try and share screen there. So New South Wales is grappling with a situation that Queensland's been grappling with for some time. And this is about whether it is reasonable or not for a body corporate to completely prohibit pets. And there's been a few twists and turns in the situation. The New South Wales government is more or less on the verge of passing legislation which will bring it into line with effectively how Queensland, now I'm simplifying things a bit there, but effectively the New South Wales government is going to bring Queensland into line and say that a blanket ban on pets is unreasonable or oppressive, words to that effect. But in this particular situation, the QCAT equivalent in New South Wales said that it was appropriate for a body corporate to have some kind of prohibition on keeping dogs, but not cats. A fascinating turn of events, that one. And if you sort of find that story on the internet, you'll see there's a bit to it. And some of that might be superseded in the next, it's very close, I believe, that decision. We'll just stop sharing there for a moment. We hear a lot about pets. Frank and I talk a lot about pets in these seminars. People are always talking about pets in body corporate situations. I was on a panel at that conference last week and somebody talked about pets in that context as well. So what's the answer here? What are we actually looking at? Well, the QUT recommendation actually said that if a body corporate passed a prohibition on pets and passed it by a resolution without dissent, then that should stand. And there should be an amendment to the legislation which allows for that to happen and which says that the body corporate can do that and it would not be oppressive or unreasonable. So in other words, think about it this way. You're a body corporate and for whatever reason you've decided as a body corporate you'd like your building to be pet free. So you put up a motion to a general meeting that a bylaw be passed prohibiting pets. This is assuming that the legislation has been changed to allow you to do that. You pass it by a resolution without dissent. And remember, a resolution without dissent is not unanimous. It means that no one has said no. If you pass that, it's passed and the building can be pet free under those circumstances. The QUT recommendation said that that should not be retrospective, so it should only apply from whatever point the law passes into the future, or it can apply from the start of new buildings. And you can see a bit of sense in that one, can't you? That if a new building puts that in place to begin with, and it's marketed that way along the way, then it makes sense that that's how it will go. I think the interesting thing for people to start thinking about there is what are some of the details around that. So this is where the thinking now needs to start from all participants in the body corporate sector in Queensland, including owners, including occupiers and real estate agents. That's tenants and real estate agents, because this has an implication for them as well. This is where the thinking caps really need to get on. So let's just say that all happens and that pet bylaw passes, or that no pet bylaw passes. Does that mean that that no pet bylaw can be challenged in the Commissioner's office? Because remember, outcomes of a resolution without dissent can be challenged in the Commissioner's office. Is there going to have to be an exception for that? Should there also be some kind of mandatory information or education circulated before the general meeting about that topic? So say, for example, the body corporate is going to consider a prohibitory bylaw, and it is enabled to do that. Should it also come with some requirement to circulate information beforehand, clearly spelling out what's involved in that situation? Some kind of warning notice, effectively, to people, so that they can start to prepare for that situation. Because that is also how the QUT review is treating the issue of smoking. The very same situation, they're suggesting more or less the same thing, that if a body corporate agrees by resolution without dissent, then it can effectively prohibit smoking. And this then goes on to, I suppose, this is one way of regulating the problem of smoke drift. But again, what we're talking about here is a big change to people's rights, a big change to how they live in their homes. What sort of preparatory work or what sort of lead-in work needs to be done to make that as fair and as reasonable as possible? Would love to hear your views on that one. Let me know what you think. Another big issue that government is going to have to face is towing. I can't begin to tell you the number of times I get asked questions about towing on a day-to-day basis, at seminars, or in webinars. The QUT review, and I'll put up a link to all of the QUT papers a bit later on. The QUT review looked at towing in terms of urgent matters and not so urgent matters. The QUT review actually recommended that if there is an urgent situation, and by urgent they mean a car is blocking utility infrastructure, something, or maybe even a fire escape, that the body corporate be able to tow without any warning or without issuing any notice to the owner of the offending vehicle. An interesting one, that one. Then they also made a distinction about so non-urgent situations and about what provisions need to be changed there. And effectively where they're going on that one, where they were going on that one, is that there should be an express legislative provision allowing bodies corporate to tow, but there should also be a bit of a process prescribed that goes with that as well. They also touched upon the issue of whether individual owners should have a right to tow vehicles if somebody is parking in their exclusive use space. Decided, and the QUT review did not make a recommendation on, or recommended no change on that one. I think that raises all sorts of issues. One of the issues it does raise for me is the issue of visitors, and about people who are neither owners or occupiers but genuine visitors to the scheme and who outstay their welcome in a park. Are they going to be covered under these same provisions that everybody else would be in that particular situation? And again, what kind of resolution, what kind of authority is needed by the body corporate to enable the towing? Is it going to be another resolution without dissent? What kind of information and education is going to be needed? And also linking it to the fact that if a body corporate is going to tow, then they need to use a licensed tow truck operator. There are a lot of questions to be answered in that one. There are a lot of vested interests in that. Again, we'd be really keen to hear your thoughts about what you think should happen. Another issue that we have heard about from time to time, not even time to time, a lot, is about regulation of body corporate managers. So at the moment, a body corporate manager in Queensland is not licensed and is not regulated. So they're not like real estate agents, for example. The government has made some fairly strong public statements about their intention to have the sector regulated, and indeed the peak body, the SCA, and full disclosure, I'm a board member of the SCA, that's their position as well. The question is, what does regulation mean and what does it look like? Whenever people think about regulation, they think about licensing. And whenever people think about licensing in this context, they usually think about real estate licensing. So that means things like trust accounting and disciplinary procedures and complaints management and inspectors and spot checks and audits. That's a lot of time, that's a lot of effort, and that's a lot of money as well. someone somewhere somehow would need to pay for all of that, and that someone somewhere somehow is bound to be the owner, bound to be owners in a body corporate. So is there another way? Do we just want to focus on trust accounting? Do we just want to focus on continuing professional development? Do we just want some mechanism to enable parties to be able to pursue disputes? That one's got a long way to play out. Again, really interested to get your views on how that might happen. One of the other issues that the review is very likely to look at is the issue of caretaking and about disputes which come up in caretaking, and it happens a lot. We get, and I know I deal with it on a day-to-day basis, disputes between committee and caretaker, and usually it's about the performance of the caretaker's contract. What does this clause mean? And one party thinking it means this and the other party thinking it means that. At the moment, the process for addressing disputes of that nature is pretty cumbersome and very expensive and time consuming. It doesn't get solved easily and it costs an awful lot of money. Is there a better way of getting that sort of thing resolved? Where does mediation lie in that process? Where does alternative dispute resolution lie in that process? There's a lot of money, as I said before, there's a lot of money and there's a lot of big contractual issues involved in that sort of thing. We need to have a think about the process. And probably the other quick one is the role of my former office, the Commissioner's office. What additional powers, if any, does that office need to be able to do its job? I am a very big proponent of the idea that the Commissioner should have the ability to declare individuals vexatious. I think there should also be some consequences on respondents, perhaps cost orders against respondents. I think there might also need to be a look at whether or not there are different kinds of disputes, a tiered dispute resolution service for relatively minor disputes and really significant ones as well. All of that is what's forthcoming. Now I need to do a bit of reality checking with everybody, because whenever you talk about legislative change and looking ahead, the tendency is to say, oh, well, I want this, this, and this, and that's all I want. Well and good. What people need to be aware of is that the pace of change is slow. I have been a person who's drafted legislation and it takes a long time, and it takes a long time because there are obligations about ensuring checks and balances and making sure that all of the pros and cons have been covered off. Trying to get all of those, even all of those concerns on the table, is going to take time. It's difficult, and because of all the vested interests in the sector, it means that compromise will be needed somewhere. People are going to have to concede somewhere, and people are going to have to accept that they won't necessarily get everything. I think there also needs to be an acceptance that perhaps some issues might be a bit resistant to a solution. And one of the analogies I'll use there is about smoke drift, and I've said this in many public seminars. You're talking about a non-solid mass. That's what smoke is. It's a non-solid mass, and yet you want to find some way to regulate it. To me, that seems like a bit of a practical challenge, but we'll see where we get to. You've also got to accept that if you want change, if you want legislative change, that's fine. You might actually find yourself being in a situation where you don't get the change you want, and in fact, the change which happens is something that is very contrary to your interests. Some of your rights might be reduced. If, for example, a prohibition on pets law came into effect, or the ability to prohibit pets, that might have a really negative impact upon you and your apartment and your way of life. And I suppose the other reality check is that anything that costs a lot of money might be a struggle to get up. So it's all well and good to ask for the Rolls-Royce system of licensing, for example, but if that costs a lot of money, you've got to be prepared to find a way to pay for that. So we've talked about the process, we've talked about some of the issues, we've talked about the reality checking that needs to go with that sort of thing. As always in these seminars, I'll give you my best practice, and there is actually best practice when it comes to legislative change. So whether you are part of a group, whether you're part of a business, whether you're an individual, and you are really keen to see something change in body corporate legislation, I think there are some things you can do, and here are my best practice tips. The first one, identify your priorities and be very specific about it. Sounds simple, but it actually requires a bit of skill. So if you're sitting there and you're thinking, all caretakers, all managers are terrible. Okay, fine. You do need to be a bit more specific than that. What do you actually mean? What's the problem? And you start from that very wide position, and you need to narrow it down, because once it's narrowed down, that's when you can start looking at solutions, and you find that the whole, oh, blah, blah is terrible, actually reduces to a very specific problem that can then be prioritized, and then you can come up with an answer for that. My second best practice tip, you need to have a solution as well as a problem. So I go back to the pets example. We talked about the problem, the disputes which arise, and it still is one of the most disputed topics in the Commissioner's office. But I also highlighted all of the areas which would need a solution in that regard, and you should be prepared to have those solutions in place. For example, if there's going to be a prohibitory pet bylaw passed, what happens to any pets currently in the building? Is there a grace period? What's the grace period? What about if they have to be relocated? That kind of thing. My third best practice tip, you need to participate. So if you are not part of the solution, then you are in effect part of the problem in this particular situation. So when the government calls for submissions, or when views are sought, or if your input is asked for, pipe up and give it and be part of the process. If you don't, then I personally feel that you lose all right to complain later on. You need to be part of the process. And related to that, the next best practice tip is get involved with your local member of parliament. Your local member of parliament's job is to represent the views of constituents. Get onto your local member of parliament and get your views in front of your local member of parliament. That's how change can be effective. Back to the idea of priorities, I think it's a really good idea to have a plan A and a plan B when you're talking about it. So by all means, have a position that you want taken forward. Smoking banned. Okay, that's what you want. What's your plan B? Well, if we can't have smoking banned, then maybe we can think about a scenario whereby the hours are very limited, or it doesn't happen on balconies, or something like that. Have a position by all means, and have a priority, but also be prepared to concede upon that. Be realistic. We've already covered that to a certain extent. Consider being part of groups. There are plenty of not-for-profit groups out there who are in the body corporate sector. If you feel passionately about an issue, get involved and be part of those situations. And I guess the final thing is to stay informed and get knowledgeable. And the best way you do that, you can start with us. Subscribe to our newsletter. We will be punching out this information as it goes along. As will the various other players in the process as well. Now, I'm just going to put up here a link to the previous QUT papers, because that's the basis on which I talked a lot today about possibilities and options moving into the future. You can have a look at all of the past papers there. There's some really good reading there, and there's a whole body of work around disclosure that we haven't even gotten to yet, but which will be another government priority in this term of government, I would think. There's a question there from Rita, which isn't directly related to this, but we'll answer it anyway. Is smoking allowed, prohibited in pool areas? A pool area is common property, Rita, and the body corporate can regulate common property. And it might be possible to regulate smoking on common property depending upon the circumstances. So it's not a yes/no answer, I'm afraid, but generally speaking, it's a bit difficult for a body corporate to prohibit smoking totally and absolutely. We've reached more or less the end today. I hope that discussion has stimulated your ideas. As I say, we'd be really keen to see people just throw their ideas up there and get a bit of a conversation happening, be it on our YouTube page or on our Facebook page. Next week, before I forget, Frank will be back, God willing, and we are going to have the second of our Ask a Body Corporate Expert Anything webinars. So we held the first one of those a month or two ago. We're going to hold the second of those next week. You can ask anybody corporate question within reason, and Frank and I will answer it without giving legal advice. So start thinking about your questions. They can be on anybody corporate topic. You can post them to YouTube or Facebook. You can email us, or you can post them live upon the day, and we'll try and get through as many of those as possible. But for now, thank you so much for tuning in. As I say, don't forget to register for reminders for our webinars. I'm Chris. Thank you for being part of my solo presentation today. We'll see you all next week. Bye-bye.